Very brief. I realize your lordships are very keen to hear a detached voice rather than partisan interest. So I'll just state my proposition. My learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. Now, the question of disqualification, and what incidentally I hope to answer my Lord Narasimha's query. The question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. Although there is no concept of potential or deemed disqualification, it has to be actual, not a deemed fictional one. The entire case of the other side, trying to link disqualification with inter-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the deputy speaker, in this case, there was no speaker because the then speaker had resigned since 5th February 2021. But the deputy speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House for his position as deputy speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as deputy speaker, i.e., the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it. But it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the Speaker of the Deputy Speakers, a majority is itself questioned, he must desist from the adjudication process. Now, it's not just Navam Varia, which is one of the questions of law propounded. Navam Varia does say so. And we're having a second look at it, but also Article 181. Then we've got two more propositions. Yes. Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner, is determinative of this matter. That's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned. Sorry, 29th July. June. Sorry, June. 29th June. I'm so sorry. 29th June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the Chief Minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the House, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Ramesh Daya of 2007, I'll give us the citation. Ramesh Prasad. In that judgment, the court said when the governor is setting about the task, and it's paragraph 161 in particular, what should we just know? When he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Ramesh Prasad.
Yes. 2006 to SEC page 1. Legislative Assembly of a state shall, as soon as they be, choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification? And my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord, I will pay.
Thank you, Mr. Datar.
Just one question of Justice. There is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10 schedule and the election commission. It's a division bench of the Kerala High Court.
What is the citation?
Yes. Okay. It's in the compilation. It's 2021 4 KLT SN 33, page 51. But it's in our compilation and it's judgment number 7 in our compilation of it. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned, and the impact of each.
Mr. Solicitor,